Welcome back to Hardball. The Bush administration is in another battle to keep its records confidential. This, as the Justice Department is contending that the White House Office of Administration is not subject to the Freedom of Information Act. The department's argument is in response to a lawsuit trying to force the office to reveal what it knows about the disappearance of White House emails last month. Can the White House ignore legal requests for email records? That's the Hardball debate tonight. Melanie Sloan is Executive Director of Citizens for Responsibility and Ethics in Washington. Her organization is the one that filed a lawsuit in May seeking Office of Administration records about the missing emails. And Attorney David Rivkin is a former official at the Department of Justice under President Bush 41. David, what's the White House up to here? What are they trying to hide? Why are they doing this?
This is actually not even hardball, this is easy ball. They're not trying to hide anything. The simple matter of fact is that Freedom of Information Act does not, repeat, does not apply to an entity like Office of Administration within the Executive Office of the President. Incidentally, I served in the White House in the two administrations, quite familiar with the structure. This is an office that performs important but essentially ministerial functions, the kind of things my law firm hires Pitney Bowes to perform. They have no substantial independent authority. Look, Congress, this is not even a confrontation over constitutional issues. This is not resisting congressional subpoenas. It's very simple. Congress made a choice in FOIA to exempt entities within the Executive Office of a President, not all, but some, like this office. Look, we have two leading cases.
Okay.
One includes National Security Council. There's a lot more stroke in case Stout Armstrong, where National Security Council was not held to be an agency. Office of Economic Advisors, that has enormous power, was also held not to be an agency. The bottom line is, people who bring those lawsuits are just interested in pushing the envelope and use the courtroom to change the existing law. They should go to Congress.
Okay. Melanie, I guess after listening to David, I mean, you should just get up and leave. You've been pushing the envelope. What are you doing in court here?
Well, I'm pretty comfortable in court here. Even on the White House's own website, you can see that the Office of Administration is covered by the FOIA. It is one of the 6 offices the White House itself has claimed is an office subject to FOIA within the Executive Office of the President. They have answered FOIAs in the past at least 65 times. Responding to a FOIA, when suddenly on a dime they turned around and said, oh no, never mind, we're actually not an agency subject to the FOIA. And that's because they're trying to hide.
Melanie, what were you seeking?
We were seeking not actual email themselves, but we were seeking information about why the White House lost over 5 million email, which the White House has admitted to, between 2003 and 2005. And the Office of Administration had given the White House a plan to recover those email, and then the White House counsel's office had refused to do it. We wanted the information about how those email came to be lost, what the body of email were lost, and what the plan was to recover them.
Okay, David, I realize you don't work in the White House right now, but do you know anything about the 5 million missing emails? Is Rosemary Wood still on the payroll that we don't know?
Of course not, but let me say 2 things. Melanie is absolutely right. In the past, Office of Administration responded to FOIAs. In the case I mentioned, Stout Armstrong, which is actually brought by one of Melanie's colleagues, who's sort of a dean of the National Security Archives, created it. The National Security Council also in the past responded to FOIA requests, and the court said very clearly, but past practice is not dispositive. If you are not an agency with meaning of FOIA, you don't become one because it's a matter of grace or by mistake. You do those things. But let's be clear, why are we always looking for some evidence of wrongful motivation? This is a law that is designed to accomplish certain things. Go to Congress, have them change the law. Look, again, I want Melanie, hold on. I want Melanie,
just provide the information right off the bat.
I don't understand the argument.
Let Melanie respond, David. Let Melanie respond.
I think that the White House has decided they were responding, and then the Office of Administration was told to stop responding, not to respond. They don't want to give us the information, not the emails themselves, which we're not trying to get, but just how it came to be that over 5 million email were lost. Those are records that are supposed to be stored under the Presidential Records Act. This is a pretty serious matter.
Melanie, let me ask you something. Why do you want to see these emails? You got a lot of time on your hands?
We want to know why it is that the White House isn't conforming with the Presidential Records Act, which requires them to maintain all electronic records. And here they failed to do it.
Aren't there bigger issues in this life in this country of ours?
There are certainly very serious issues facing this country all the time, but the law is the law, and the White House is not above the law. They should be abiding by the Presidential Records Act and saving all of these email for future generations. The question is, why does the White House not want future generations to understand what they were up to? What are they hiding?
That is nonsense. With all due respect, the real issue is different. Organizations like Melanie's, and they are bipartisan to be fair. In every administration, Republican and Democrat, they come in and ask for every document under the sun. To answer your question, Mike, they want to know. Look, the fundamental problem is this. There's no sense of balance here. They're like PETA. If you ask PETA, you never do any animal testing. If you ask pharmaceutical industry, you do animal testing all the time. Somebody has to balance things. In this instance, it's Congress. Congress came up with a law that does not include such entities.
Okay.
I don't understand. If National Security Council is not an agency and they have a lot of power in policy making, how is it that Office of Administration but basically runs computers as an agency?
David?
Melanie knows well.
Up until Tuesday, the White House was saying that they were such an agency.
That is not.
This is a totally new argument.
That is not a dispositive argument.
Okay.
In the case I mentioned, the court said it doesn't matter what they've done in the past.
Melanie Sloan, David Rivkin, we have to cut it off there. I'm sorry, but actually I thought when you were talking about FOIA, you were talking about the hallway in the White House. That's how much I know about this issue.